Sometimes your insurance companies can get things wrong, and they can accept liability and they can pay out to the other party, even though it's not in accordance with the law. As in one video by Ashley Neal this morning I found very interesting. I will link that in the description below. You can go and watch that. And I'm going to give you my view in this video of who I believe was more liable for that minor collision. And you can go and watch Ashley's video and let me know what you think in the comments below. So in this situation, it was to do with what was effectively an unmarked junction. It wasn't actually unmarked. The traffic lights were out, but that rendered it, in my view, an unmarked junction. And Ashley quite rightly points out in that video that there are two rules of the highway code that kick in, Rule 176 and Rule 146. So I'm going to go through a little bit of that and what the law says underneath it. But starting at the very beginning, there are a couple of fundamental things to understand here. First of all, to do with the highway code, many people believe that they are just guidance and not law at all and shouldn't be followed. Whereas I can tell you that lots of the rules are backed up in law and therefore create offences if you do or don't do things that are required in the highway code. But also, generally speaking, if you break some of those rules and you end up in court, then barristers like me are going to put those indiscretions to you, telling you that you've broken the rules, and then make my case to the judge that you are more liable than my client. But there's another interesting point to Ashley's video, in that it suggests that the insurance company did not accept that the highway code is law. According to Ashley's viewer, the insurance company said that it's just guidelines and not law, when in fact it is law, and for all the reasons that I've just said, if you break any of those rules in the highway code, you are much more likely to be liable in court. Now, coming back to the unmarked roads situation, the other fundamental thing in the highway code is that the highway code does not provide anybody any absolute right of way. Many people use the phrase that I have right of way because of XYZ rule in the highway code, but that's simply not true. The highway code itself says that it does not provide any one person or another a right of way in any circumstance. What it does do is provide certain levels of hierarchy and priority as to when you should give way to another person. And if you should have given way and didn't, that's when you'll be found liable in court. And there's a very trite principle of law. Every motorist is going to have a duty of care to every other road user. And if you're found to have breached that duty of care to another road user, then you'll be negligent. And that's the principle on which you are found liable for road traffic collisions. It's a principle of negligence. You first establish that there is a duty of care, not usually difficult to do, but if you're on the road, it's given. You have a duty of care to every other road user. If there's a collision, then the argument in court is to who was negligent or who was more negligent, because both parties might well be negligent. As Ashley mentioned in his video, his viewer was not 100% liable. I would agree with that. I would say that the other driver coming in the other direction was very much more liable. And even if it were found by a court that Ashley's viewer was partly responsible and partly negligent, the other driver is almost certainly going to have contributory negligence attributed to them. And that can be up to 100%. So even if a court held that Ashley's driver wasn't driving entirely properly, the other driver can be held liable with contributory negligence up to 100%, meaning that they pay for all the damage. But the bit that I found really interesting in Ashley's video is that the insurance company accepted liability on the basis of the dashcam footage to say that Ashley's viewer didn't give way when there was no legal requirement for him to do so, because in the highway code, no one has an absolute priority, as I've mentioned, and with an unmarked junction, again, no one has priority over each other. And in the situation where the traffic lights are not working, it is to be treated as an unmarked junction. And as Ashley pointed out, this is referenced in the highway code at Rule 176. At the outset of Rule 176, it says you must not move forward over the white line when the red light is showing. In other words, if there is a red light, working or otherwise, if there is a red light, you must not move over the line. Those are provided in law. Only go forward when the traffic lights are green, etc. But in the final sentence, if the traffic lights are not working, treat the situation as you would an unmarked junction and proceed with great care. And as Ashley pointed out, going back to Rule 146 for an unmarked junction, it says look out for unmarked junctions where nobody has priority. And as I mentioned at the outset of the highway code, the highway code does not provide any right of way between one person or another. But as I said, the most interesting part about this is that the insurance company accepted liability on the basis of this dashcam footage, when in my view the other driver was clearly very much more responsible for the collision. As I said, you can go and watch that video linked below, but in my view the other driver was far more liable for that collision, if not up to 100% with contributory negligence. But then there comes the question as to what happens with your no claims discount if it's not protected, that is. If it's protected, it means you won't lose the no claims discount in the event of a collision and a claim. But let's say that you don't have protected no claims, and then you're going to lose your no claims bonus, resulting in a massive hike in your insurance premium for the following year. I think there is potential scope here to argue a breach of contract on the part of your insurance company if they've accepted liability in a situation where they really shouldn't. Now, there will be some terms within the terms and conditions of your insurance company that says that they can accept liability for a claim if they are of the view that it's not worth fighting it in court. However, if this has a detrimental effect against you, the consumer, and that term is then potentially found to be unfair, if a term is unfair, then it's unenforceable, because all contracts that are consumer contracts, at least, assuming this driver in the video is a consumer, all contracts that are consumer contracts are subject to the Consumer Rights Act of 2015. If any other company wants to argue that you are not a consumer, unlike some arguments I've had with companies that write to me when I'm representing someone as a barrister, they say, you've got to prove it. I say, no, that's not true. You must prove that my client is not a consumer. If my client says that they are a consumer and they provide some kind of evidence and documentation that they are a consumer, it's for the other side to prove that they are not a consumer. So assuming that they are a consumer in this situation, if a term is rendered to be unfair, then it would be unenforceable. In my view, there is scope to argue here that if the insurance company has a blanket rule to say they can make these decisions, and then regardless of any kind of argument over liability, that's just tough, you'll lose your no claims discount, and then next year, whichever company you choose to go with your insurance, if your insurance is hiked because you've lost your no claims bonus, I think there's an argument to be had there, because that's just not right. And if it's not right, it's arguable. Now, as I often say on this channel, the law is very, very rarely black and white. If it was absolutely crystal clear every single time, there wouldn't be need for barristers like us. We have these arguments, we have different views. Some people say, oh, well, XYZ lawyer or barrister disagrees with the black belt barrister. That's absolutely fine. What do you think happens when we go to court? Because it's not necessarily that we disagree over the view, but we are putting an alternative legal view to the court. And ultimately, unless those decisions, unless those cases have gone all the way to the Supreme Court and absolutely ruled against any principle, it's still open for discussion. But that's my brief input on this situation for a Saturday morning. I thought that was a very interesting situation, and I'd be quite annoyed if my insurance company was accepting liability for something that really wasn't my fault. Because if I were the driver in that situation, yes, I would agree that there is some responsibility on my part, but the other driver in the other direction, in my view, was far more liable because of the sheer speed at which they were driving through this junction, clearly in contravention of the highway code and the general trite principle of law to take reasonable care over the road users as per the duty bestowed upon you by using the roads in the first place. So let me know what you think in the comments below. I'll give you a moment now to smash that like button on this video, and please do subscribe, because I want to rocket my subscribers. I want to reach 1 million subscribers, because my mission and goal now is to help 1 million people understand law. Thank you for watching.